Good morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime, where we cover some of the most interesting live trials in the country today. We were off last week, but we are back this week, and we have a very, very exciting and trial-packed week for you, and it's all starting today. Let's get started. Well, I should tell you what's happening tomorrow, because tomorrow we are going to begin the Tex MacGyver case out of Atlanta. I'm sure many of you have heard about this case. We've been talking about it a lot here on the network. This is that case of that prominent Atlanta attorney who faces 7 charges, including malice murder in the September 2016 shooting death of his wife, Diane MacGyver. Now, the couple was riding in their SUV with a friend when MacGyver shot his wife through the back. That might seem like an open and shut case, but it's not. The defense is saying that that was a mere accident, that the gun went off itself. So this, where the prosecution is saying it was intentional murder versus this accident, will play out tomorrow. We're going to start covering that. That will be our main case of the week. But we have a very, very busy day today. First off, for anybody who's been following us last week, as you know, we've been covering the Brian Flatoff case. This case out of Wisconsin. This man who was engaged in an armed standoff with police by holding several hostages at gunpoint. This was at a motorcycle repair shop. Now, he was found guilty last week. That's right. He was found guilty by a jury of his peers on all 14 counts, and that included felony murder and 2 counts of attempted murder. This includes Flatoff was found guilty of causing the death of Michael Funk, who was one of the hostages, because during the standoff, Funk was shot and killed by police mistakenly. They thought that he was the gunman. And as you know, under the felony murder laws, because Brian Flatoff was the one that actually created this whole situation and was engaged in a felony at the time, and someone died, he is now responsible for the death of Mr. Funk. But that's not where the story ends, because even though he was found guilty last week, today begins the second phase of this case, the penalty phase. What the jury has to listen to now is whether or not Mr. Flatoff was mentally responsible for his actions, or was he impaired by a mental disease or defect at the time of the offense. A lot of you have heard about this. This is the insanity defense, folks. We're going to talk about this a little bit later. And there's a lot at stake in the Flatoff case because Mr. Flatoff faces upwards to 300 years in prison. That's the maximum. We'll talk about that in a little bit. But our main trial for the day, a case that has taken the nation by storm, and we are covering it here on Law and Crime, and you don't want to miss anything. This is the case of James Worley out of Ohio. Now, jury selection will finalize this morning. We expect opening statements today at around 10:30 a.m. Now, 58-year-old James Worley, he's on trial for the abduction and murder of a 20-year-old University of Toledo student named Sierra Joggin back in July of 2016. We have a short preview of this case. I want to play it for you right now.
The trial of James Dean Worley is underway in Ohio. Worley is accused of killing a 20-year-old woman. On July 19, 2016, Sierra Joggin went for a bike ride with her boyfriend in a rural area of Fulton County, Ohio. At the end of the ride, the two parted ways, and that was the last time the young University of Toledo student would be seen alive. When Sierra didn't make it home that night, her mother filed a missing persons report. Local law enforcement officials began the frantic search for the young woman, gone without a trace. Investigators found their first break in the case, Sierra's bicycle, in a nearby cornfield. The abandoned bike was found alongside a motorcycle helmet, bloodstains, and signs of a struggle. These clues would lead police to the shallow grave off of County Road 7, where Sierra's body was found.
Authorities searching an area around County Road 7 tragically found what we believe to be Sierra's remains.
Local Delta resident James Worley would become the focus of the investigation after he admitted to being in the area where the bicycle was found. Worley claimed his motorcycle had broken down when he rolled into a nearby cornfield and discovered the abandoned bike. But investigators became very suspicious of the 57-year-old when they observed fresh scratches and bruising on his arms and legs. But it was the search of Worley's property that shocked this small Ohio town. While searching his property, investigators found a hidden room inside the barn. The room contained a carpet-lined freezer, handcuffs and restraints, and blood stains on the walls and floors. Investigators seized multiple pairs of women's underwear, handguns, a shock collar, and a rope. And making this case even stranger, Worley was convicted for abducting another woman riding her bike in 1990 and was released after serving just 3 years in prison. We'll be covering this trial on the Law and Crime Network and keep you updated on the case. For Law and Crime, I'm Rachel Stockman.
You can't make this stuff up, ladies and gentlemen. It's as horrific as it sounds. That case will again begin at 10:30 a.m. Eastern Standard Time. You don't want to miss it. But before we cover it, let's talk a little bit about it. I'm very happy we have a new guest with us right now, criminal defense attorney Carissa Kranz. Carissa, great to have you here on the program.
Thanks for having me.
Let's talk a little bit about this Worley case. We showed our preview of it. A lot at stake here, a lot of different factors, a lot of disturbing details involved in this case. Now, we know the jury will be finalizing today. They were going to try to get a jury by this morning. How difficult is it to get a jury that's unbiased, that doesn't know that much about this case or anything at all in this small community?
In this case, it's very difficult, and that's why they started out with such a large jury pool. Today, they have about 50 jurors, and they're going to try to cut it down to 18. They're going to want 12 on the panel and 6 alternates. The reason they want 6 alternates is because if a juror has to leave, they want to make sure they have enough backup so there's no mistrial called for lack of a juror. This case is going to be a long, drawn-out trial. It costs lots of money to try these cases. It takes jurors' time, it takes attorneys' time, it takes the judges' time. And in this case, with so much media exposure already before the trial even begins, you have to make sure you find a jury panel that's not biased, a panel that is completely vetted and that can follow the law. So, you know, jury selection's an art, voir dire is an art, and experts are hired all the time to help in jury selection because it is arguably the most important part of a trial, because that panel, those members, are going to decide the fate and the outcome of the case.
And also because of the disturbing details of this case, right? I mean, just listening to what it's about might be like, I can't do this. I can't do this case. And let's not forget, this is a capital murder case.
Right.
So these same jurors will have to decide, if he's found guilty, whether they should sentence him to death.
Right. So during jury selection, they're going to have to be asked whether or not they have a personal belief about the death penalty. And then the attorneys have to probe further that despite any personal belief about the death penalty, can they set that aside and follow the law as instructed based on how the law is that the death penalty is an option.
That's easier said than done, though.
Well, it is, because people have their own religious beliefs, their own personal beliefs, and as much as you try to say bias and say that you can follow the law and I'm not going to bring any prejudice to the stand, that's really difficult to do because we're all complex human beings and we bring our own life experiences to the table. And then you have to shut out any thought that you've even seen this on TV or in the newspapers. That's why jurors are often sequestered in trials. Yes.
And they might have to be in this case because there's so much media attention. But as we said, this is not the only case that has garnered attention. We are also covering the Brian Flatoff case. Now, that will resume today at 9:30 a.m. Eastern Standard Time. We are going to cover it here on Law and Crime. Again, this case of a man who was found guilty on 14 counts related to a hostage situation. He engaged in an armed standoff with police, and one person was killed as a result of that standoff. Now, I should note, he wasn't killed directly by Flatoff. He was killed by police officers who mistook this man for Mr. Flatoff, but regardless, Flatoff is responsible for his death. What I want to play for you right now, in case you missed it, and as we wait for the 9:30 a.m. time today, I want to play for you the prosecution's opening in the Flatoff case. And let's not forget, for the first 4 days of this case, Brian Flatoff represented himself. We'll talk about that in a minute. Here's the prosecution's opening from last week.
Ladies and gentlemen of the jury, in August of 2015, the defendant, Brian Flatoff, was arrested for a felony offense in Outagamie County. And after his arrest, he had contacted an acquaintance of his, Vance Dalton, to see if he'd get him to post his $3,000 cash bond. Vance was a working man, a family man, didn't want to put up the money, maybe didn't have the money to do that just out of pocket, so he negotiated with the defendant to take his motorcycle and he put it up for collateral on a loan to secure his bail. And he was able to get that loan for $4,500, and he put up the $3,000, and he gave the defendant the remaining $1,500 cash. In exchange, Brian Flatoff signed over the title to his motorcycle. Now, this is not going to be a trial regarding who's the owner of the motorcycle. The defendant began to dispute this and how Vance Dalton came into possession of this motorcycle. But this is only relevant for the background information as to why on the morning of December 5th, 2015, the defendant armed himself with a firearm, a 9mm MAC-10 style pistol, 2 33-round full magazines and 2 daggers, and went to the Eagle Nation Cycles shop in the city of Neenah, here in Winnebago County, Wisconsin. Leading up to December 5th, beginning in about October of 2015, the defendant started sending Vance Dalton letters, calling him, demanding to have his motorcycle back. And Vance was refusing this because he was on the hook for the $4,500 loan, and essentially said, if you can put up the money for it, pay me back, you can have it back, which the defendant apparently could not do, and his phone calls became progressively more threatening throughout the month into November. The defendant began threatening Vance Dalton's life. He began threatening to kill him, his children, his wife, if he did not get the motorcycle back. This proceeded to, it was November 23rd, Vance Dalton wrote a letter to the Outagamie County judge advising him of these threats, essentially asking that the bond be revoked. Now, unfortunately, as we've seen recently across the country, following acts of gun violence, we uncover that there was dire predictions that were not followed through, and such as
That was the prosecution's opening statements in the Brian Flatoff case, which we covered last week, and today begins the second phase of this case to determine whether or not he was mentally responsible for his actions, or did he suffer from a mental disease or defect? That becomes the question. But first, we know that he was found guilty. Let's talk about that. Again, I'm here with criminal defense attorney Carissa Kranz. Were you surprised by that verdict? I mean, they had him on surveillance footage, literally committing the crime.
I'm not at all surprised by the verdict. I think that now it's going to come down to whether or not he is guilty or not guilty by reason of mental defect.
Let's talk about it. So he was found guilty of 14 crimes, okay? 14 crimes, not surprised. He represented himself. Maybe a mistake.
After going through about 10 attorneys.
Right. We'll talk about that in a minute. Yeah. But now what is happening today? What is really going on here?
So today is phase 2. It's like this is another trial after the trial. So the first trial happened where the state had to prove its case beyond any and all reasonable doubt whether or not he was guilty. Now that he is found guilty, since he filed a motion saying not guilty he pled not guilty, and then he filed a motion to enter a plea of not guilty by reason of insanity. Now we're into phase 2 because he was found guilty on whether or not he is not guilty by reason of insanity. So this is another mini trial with the same jury. The burden now shifts. So the state had the burden to prove his guilt, but now he has the burden to prove that he is not guilty by reason of insanity, and the burden is not as high. For the trial, it was beyond any and all reasonable doubt, but for a competency trial or a mental defect trial, this one's mental defect. That's different than mental competency. The standard is clear and convincing evidence, so it's a lower standard.
Okay, so he faces anywhere upwards of almost 300 years in prison. That's the maximum sentence. Right. So what happens if he's deemed by a jury that he was not mentally responsible, that he is insane? What happens then?
Well, then he will spend his time in a mental institution rather than a prison.
But okay, I see that. How difficult is that for him to do, to try to prove that?
You know, mental illness and mental defect is the most common criminal defense to use, and it is a very hard criminal defense to win on.
I can imagine so.
You know, this case is actually really interesting, though, because since he represented himself, the jury has a real inside view onto how he thinks and possibly his own mental state. So even though a mental defect trial, the second phase of the trial, is a battle of the experts, it's the same jury. So this jury is going to bring their own experiences to their evaluation on whether or not he is insane.
Well, I have to ask you the million-dollar question, and we might be taking a break, so I might have to ask you after, is whether or not him representing himself, because anybody who's been following this case knows that for the first 3 or 4 days of this case, he was representing himself. He provided an opening statement. He even cross-examined some of the witnesses. He went through 10 attorneys, Carissa, like you said, And then the attorney, then at the fourth day, he asked for a new attorney.
Right, and so, the judge determined that he was competent to stand trial. And not only was he competent to stand trial, he was competent to stand trial unrepresented with just the advice of public defenders on the sideline. So it really is now whether or not he was insane at the moment that the crime was committed, and whether or not he appreciated the difference of right and wrong at the time the crime was committed, to have a not guilty defense by reason of insanity.
Right.
Yeah.
Well, a lot to talk about in this case. Again, we do expect live coverage at 9:30 today. We're not going to want to miss anything. And again, later on, I believe now we've gotten a report that after their lunch break today, we will begin covering the James Worley case out of Ohio. So big day today, big day covering two big cases. We are going to take a quick break, and when we come back, we have two big cases to talk about. We'll be back in a minute. Welcome back to Law and Crime, everybody. We're covering two big cases today. The first one is the James Worley case out of Ohio. Now, we do expect it to begin later on the day. Now it's going to be probably the opening statements after the lunch break today. They're still working on getting that jury in this really, really disturbing case where a 58-year-old man named James Worley is now on trial for the abduction and murder of a 20-year-old University of Toledo student named Sierra Joggin. Worley is accused of kidnapping Joggin from a country road as she biked home from her boyfriend's house. He's accused of asphyxiating her and leaving her bound and gagged in a shallow grave. The details of this case don't end there, the disturbing nature of that, because when they executed search warrants on his property, there were many disturbing things, including a freezer filled with blood. A lot of details in this case that we're going to talk about that. But again, our focus right now in the early part of the morning is the Brian Flatoff case, because we believe that the trial will begin again at 9:30 a.m. This man who was found guilty by a jury of his peers last week on all 14 counts, including felony murder and 2 counts of attempted murder in regards to a hostage situation that he actually started, that he engaged in. He engaged in an armed standoff with police at a motorcycle repair shop. And during this confrontation, a man was killed, a man named Michael Funk, who police thought was the actual perpetrator. They thought he was the gunman, and they shot and killed him by mistake. But Brian Flatoff is the one who's responsible for that. What we're playing for you right now, in case you missed it, is the prosecution's opening statements from last week. And again, today begins the second part of this case to determine whether or not Mr. Flatoff is mentally responsible for his actions, or will he be declared insane? That's what we're going to talk about in a little bit. Right now, here is some more of the prosecution's opening statements.
Here, because on the morning of December 5th, 2015, approximately 8:55 a.m. or so, Vance Dalton was at home cooking breakfast for his children when he received a phone call from Ryan Motorson. Ryan Motorson had gone down to the Eagle Nation Cycle Shop that morning, as he would on a typical Saturday morning, to see his friend Michael Funk, to give him a Christmas card, to chat with his friends, and to begin working on motorcycles. And while Ryan Motorson was down there working on a motorcycle, about 8:50 or so, somewhere around that time, him and Michael Funk heard a pickup truck pull up to the rear door of Eagle Nation Cycles. Now, this was a little unusual for them, because the rear door is where people would come and drop off bikes, pick up bikes or parts or something of that nature. And so Michael Funk went outside the back door into the alley to see who was there. While Ryan Motorson was working on a motorcycle, moments later, he observed Michael Funk re-enter the Eagle Nation Cycle Shop, hands in the air, and being followed in by Brian Flatoff, who was armed at this point with a 9mm pistol, pointing it at Mr. Funk and taking him back inside the motorcycle shop. Once inside the shop, the defendant almost immediately ordered that they call Vance Dalton at home and get him down there. Brian Flatoff had come to retrieve his motorcycle, but at this point that wasn't enough. He also had come to kill Vance Dalton. And when he ordered Ryan Motorson to make that call and get him down there, this is where he engaged in this conspiracy to commit that first-degree intentional homicide. Unwillingly, but having no choice, Ryan Motorson made the call, told him Flatoff's down here, he wants you to get down here, but he secretly, quietly, was whispering to him, don't come, he's got a gun. And Vance Dalton then called 911. And he had two lines open. Now he has one call open to 911, the other to the Eagle Nation shop. And he could hear the defendant telling people, if he doesn't get down here, I'm going to start killing people. I'm going to kill his wife. I'm going to kill his children. He can hear this, and he's reporting it to 911. Now that morning on December 5th, 2015, Officer Jonathan Kufel was off duty. He is the head of the Neenah Police Department SWAT team, and he was called into duty that morning approximately 9:11 a.m. And upon arriving on scene with his SWAT gear, he began assembling a team when he was provided notice that Brian Flatoff had announced that he was going to start killing people in 5 minutes if Vance Dalton did not get down there. And at that time, the decision was made to form what law enforcement calls a hasty team. A hasty team is a dangerous situation or scenario for police because it's a team that has to effectuate an immediate entry to try to rescue hostages without having the ability to do any type of research on the layout of the building they're entering, the floor plan, or to get any type of background information on the hostage taker or the hostages. But at approximately 9:42 a.m. that morning, the hasty team, led by Lieutenants Tyrone Thompson and Sean O'Bray, and then Officer Craig Hoffer, followed by Jonathan Kufel, and brought up the fifth man, Robert Ross, decided that they had to make entry at that time, based on the countdown. And when they opened the back door to Eagle Nation, which was relatively dark inside, compared to the bright sunny day it was outside, between the contrast in light and the limited visibility of the shield, that the ballistic shield the front man had, the two lead officers were unable to see that upon entering the back door, there was an open staircase immediately to the right that dropped down to the basement. And when the two lead officers entered the rear door of Eagle Nation, they immediately stepped to the right and they plummeted down to the basement below.
Again, you're watching the prosecution's opening statements in the Brian Flatoff case, which started last week and continues today, because now the same jury that convicted him on all 14 counts in relation to that armed standoffs hostage situation that resulted in the death of one person, now that jury has to decide whether or not he suffered from a mental defect and he's not responsible for his actions. We're talking about the insanity defense. So let's talk a little bit more about that. Now I'm again, I should say, joined by former prosecutor Carissa Kranz. Carissa, let's talk a little bit about what happened in this case. Sure. We know that he represented himself for 4 days.
Right.
Question for you. If he did that, is that kind of a ploy to show this guy's not all there? Look, he tried to represent himself in his own case?
Right. Well, him being not all there, it could be the case for any criminal. Any alleged criminal, anyone found guilty has a mental defect, right? Arguably. The question is whether or not that mental defect is severe enough to qualify as a mental illness to justify a legal defense to find him not guilty.
And what do you think? I mean, we're talking. What could he argue? Because he seemed to know what was happening. He gave an well, I shouldn't say eloquent. He gave a very detailed explanation about police corruption and why, in his opening statements.
But that just means he was competent to stand in his own defense for trial. He was able to articulate now, after the fact, what's been going on. That doesn't mean that at the time the actual crimes were committed, that he had a severe mental defect that would have affected his mental state legally under the law. So that is going to come into psychiatrists evaluating him. It's going to be about all the experts. We're going to see what the psychiatrist reports say. And then the same jury that evaluated him and watched him fire 10 different public defenders and go through them like water, then has to decide, whether or not the psychiatrist's evaluation is an evaluation that they find believable by clear and convincing evidence. That's the standard.
Yeah, it's more clear and convincing as we keep saying.
And it's his burden. It's his burden to prove that he was mentally insane at the time the crimes were committed.
Well, not to make light of a really horrible situation, but it is pretty entertaining to watch what happens.
It's also, I think, important to note. There are some allegations of him having some alcohol intoxication beforehand, and you can have a mental defect because you're intoxicated by alcohol, but that is not a legal justification under the law, because voluntary intoxication is not a defense.
Because he got drunk himself.
So I think more likely he does have a mental defect, but it's due to the alcohol intoxication, which is not a legal defense. It's not going to be because of him being mentally insane.
Well, now that he is represented by counsel, maybe they'll go with another mental defect besides the drinking as well. We'll talk about that in a minute, but that's not the only case we're covering here on Law and Crime. We're also covering, the James Worley case out of Ohio, that man who is accused of abducting and murdering a 20-year-old University of Toledo student named Sierra Joggin. And we are also covering tomorrow the Tex MacGyver case out of Atlanta, that prominent attorney who's accused of intentionally shooting and killing his wife in the backseat of their SUV. Now, he and his defense team is saying it was just an accident. We have a short preview of that case that will begin tomorrow and that we're covering here on Law and Crime. Take a look.
The murder trial of a prominent Atlanta attorney is expected to start in just days. Claude Tex MacGyver, 74 years old, is charged with the 2016 shooting death of his wife, Diane. MacGyver was sitting behind Diane in the passenger seat of a car, and a friend was driving when he apparently opened fire, shooting Diane through her back. MacGyver claims the shooting was a mistake. This is what MacGyver's attorney told the judge at a bond hearing last year.
Mr. MacGyver had a pistol in his lap, and the pistol went off, or was accidentally fired. There was no argument, there was no quarrel. He was, according to Mr. Carter, he was asleep at the time. She stopped at the traffic light, and the first thing she heard was the explosion.
But prosecutors believe he had a financial motive to kill his wife. MacGyver is charged with malice murder, felony murder, and 5 other counts. We'll be streaming that trial starting Monday right here on the Law and Crime Network. I'm Rachel Stockman.
Okay, so that's the Tex MacGyver case starting tomorrow, but our focus right now is the Brian Flatoff case. Again, we're waiting for a live feed in that courtroom. As soon as we have it, we'll make sure to go to it. But Carissa, I want to talk more about the Flatoff case because he was found guilty, but there seems to be a lot of opportunity for appeal. If you could explain real quickly, because there was a whole issue with being represented by counsel and then being represented by counsel later, and then there's also issues with what he brought up in his case.
Right. So if he's not found not guilty by reason of insanity, you can bet that you're going to see an appeal. And he is going to base that appeal on ineffective assistance of counsel and the rule of completeness, which is in the federal rules. The rule of completeness means that all evidence must be considered in context so the jury is not misled and there's no prejudice or bias. And he does say that the video that was admitted as evidence is missing an hour and a half of footage. We don't know what that footage shows, but it's very likely that that footage under the rule of completeness needed to be admitted so Mr. Flatoff could have put on his case.
Yeah, he actually made a good point in his opening statement. And again, the family of Michael Funk is happy that this is slowly coming to an end. We're going to take a quick break. We'll be back in a minute. Stay tuned. Welcome back, everybody. We are covering the Brian Flatoff case out of Wisconsin, and now this case is very important because even though this man was already found guilty by a jury of his peers on 14 counts related to an armed standoff at a motorcycle shop that resulted in the death of one hostage that he didn't shoot, but the police shot and killed mistakenly, thinking it was the gunman, he's ultimately responsible. But now the question becomes, was he suffering from a mental defect at the time? Again, I'm here with former prosecutor Carissa Kranz. We're talking about this. We're talking about the appeals. We're looking at the live feed, waiting for it to start. The thing about this, though, is what I think interesting is, let's bring it back to him representing himself. Even though he represented himself for like 4 days and he brought out an opening statement, he started cross-examining witnesses, there was a danger to him doing that. Ultimately, he needed an attorney. What did you make of that?
Well, he had the advice of public defenders guiding him throughout the process. He was able to make a motion on his own to change his plea from not guilty to also not guilty by reason of insanity. You know, you can't expect him to know how to lawyer like a lawyer would lawyer, but he actually, did get through most of the trial on his own. The jury's going to have a real inside view on his ability to think and have their own opinion on what his thought process may have been at the time the crimes were committed, because he did defend himself. What's interesting, though, is even though he defended himself, he didn't take the stand.
No, he did not. He did not.
So they heard from him, but they didn't really hear from him.
It's an interesting way of providing an opening statement. It's very different than being cross-examined.
Because an opening statement's not evidence.
Exactly. That's 100% true.
So whatever he said is his narrative. That's the jury's going to consider it, but they're not supposed to.
And we talk about the opening statement because we're showing you the prosecution's opening statement. And as Carissa explained, it's not really evidence, but it's a way to show what this case is about. But I will say the jury came back with a verdict very shortly. The evidence against Mr. Flatoff was very, very convincing. There was surveillance footage of him committing the crime. There was really, even his own defense attorney, when he actually took the case, said my client is guilty of 12 of the 14 offenses. What I want to play for you again right now is the continuation of the prosecution's opening statements. Take a look.
When the two lead officers fell down into the basement, that left the third man in the hasty team stack, Officer Craig Hoffer, completely exposed without the protection of the ballistic shield and exposed to the defendant. And the defendant, despite his claims and statements this morning that he's pro-law enforcement and loves law enforcement, took a position up behind what's been called the L-shaped desk and immediately began firing at the police upon their entry, and they're yelling police. And he shot Officer Craig Hoffer right in the head above the right eye. Now, fortunately, Officer Hoffer was wearing a ballistic helmet and the bullet did not penetrate it. But he was injured. It hit just above the bottom rim, the lip of the helmet. He went down. He was screaming, "I'm hit." Officer Kufel, the next man in line, having seen the first two lead officers, from what he could tell, essentially vanished, seeing Officer Hoffer down on the ground yelling, "I'm hit," he himself is taking fire from the defendant, who continues to shoot, returned fire, and essentially, heroically, was able to extract not only Officer Hoffer, but pull the first two lieutenants that fell down the stairs out that back door and back into the alley. Once they were out in the alley, they got split up. Sergeant Angela Eichmann had taken a position on the opposite end of the alley where the hasty team had formed, and when she saw that one of them was down, she ran to the back door of Eagle Nation, helped Officer Hoffer go back up to the alley by Vicky's Hair Salon, which was a corner in the other end where they had taken a position, and Officer Kufel and Lieutenant O'Bray and Tyrone Thompson retreated back from the way they came where the team had initially formed up. Now, once having heard shots were fired, hostage negotiator Catherine Volker was able to make phone contact with the defendant, Brian Flatoff, who identified himself, and he was upset now at this point in time because the back door had been left open when the hasty team retreated. He began making orders for them to close the back door, and eventually, when Officer Volker said, "Well, I can't do that at this time," eventually the defendant ordered Michael Funk to close the back door. And Officer Volker could hear the defendant yelling at Michael Funk, something to the effect of, "If you make a run for it, I'm going to unload on your ass." And as Michael Funk approached the back door to close it, he went for it. And he tried to make a run out the back door, and the defendant, true to his word, fired approximately 5 rounds off at Michael Funk as he made his escape.
Welcome back, everybody. We're covering the Flatoff case out of Wisconsin. We do see a live feed in the courtroom. As soon as it starts, we're going to make sure to go to it because today begins the second phase of this case to determine whether or not this man suffered from a mental defect and should not be held responsible for his actions. Here's my question to you. He said he brought this case forward and really took it to trial because he wanted to expose corruption in the police department. He said the police were manufacturing these lies about him. They were trying to cover up more than was going on. In fact, at one point, Michael Funk, the individual who died as a result of this hostage situation, we know that he filed a $50 million federal lawsuit against the police regarding an unrelated raid on his motorcycle shop. And we started to see the flavor of maybe this was a cover-up, that he was shot by the police. What did you make of all that during the case?
I mean, it's a compelling argument. It goes to motive of why the police would have a motive or a reason to have Mr. Funk dead. However, I think in this case, that's a long shot. You know, Mr. Funk wouldn't be dead if Mr. Flatoff didn't commit the crime at that time. So under the felony murder rule, the police aren't guilty. Mr. Flatoff is guilty because during the commission of his felony, even though he didn't intend to kill Mr. Funk, during the commission of his other felony, Mr. Funk died, even though the police are the ones that shot him. I think a conspiracy theory is it's a long shot in this case, but it's a compelling argument in light of the civil lawsuit that was brought of $50 million. I also think it's very hard to say that the police intentionally shot Mr. Funk when he's running out the back door and people are screaming and yelling and shots are being fired and people falling downstairs and smoke's going off because a fire extinguisher got shot and there's smoke everywhere. I think it happened so fast it'd be very hard to believe that this was actually a conspiracy situation. However, what is, I think, a little unusual that can't be explained is, you know, after Mr. Funk was shot, why did no medical assistance come to his immediate aid? There are stories reporting that he was laying there on the sidewalk for over an hour bleeding.
That's what's interesting about it. That's what leaves a little bit of questions in the air. Carissa, stand by. I'm sorry. We have a live feed right now in the Brian Flatoff case, but we're going to talk more about the Michael Funk situation because there's a lot more to dissect there. Let's go right now live into the courtroom and let's listen in.
We will now proceed with the second phase of this trial. During this second phase, you will be asked to determine whether the defendant is not responsible by reason of mental disease or defect. Before you may find the defendant is not responsible for the criminal conduct, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was committed, the defendant had a mental disease or defect and as a result lacks substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of law. This issue will be presented to you in the form of two questions. The first question that you'll need to answer at the conclusion is, 1, at the time the crime was committed, did the defendant have a mental disease or defect? 2, as a result of the mental disease or defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of law? You will be asked to answer the second question only if you answer the first question yes. If you find the defendant is not responsible for the criminal conduct, the defendant will be committed to the custody of the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to himself or to others if released under conditions ordered by the court. The only issue at this second phase of the trial is the defendant's mental condition at the time of the offense. At this time, we will proceed with an opening statement. Mr. Szilagyi.
So we've started a new phase of the trial. The last phase, Brian was found guilty. And as the judge said, in this context, guilt is defined essentially as did he do what the state has alleged. Now we are concerning ourselves with, as we found that he did, what were his underlying mental conditions at the time, and did that mental condition consist of, or was it influenced by a mental disease or defect? And if so, what effect did that have on him and on his ability to make choices, to understand he's making wrong choices, or to stop himself from making wrong choices, even if he knew they were wrong. The state's burden has finished with phase 1, and it is now the defense's burden to convince you by the greater weight of credible evidence that there was a mental disease or defect and that it caused Brian Flatoff not to either know what he was doing was wrong or not to be able to control his behavior. And I hope as we hear testimony this morning that you will hold the defense to our burden just as you held the state to their burden. That you will carefully consider the evidence and you will carefully apply it to the standards with which the judge has already given you and which will be further elaborated in your instructions before deliberation. You're going to hear the testimony of Dr. Glassman this morning. He was appointed by the court to perform an evaluation of Brian and to ultimately give an opinion as to whether he thought Brian met the legal standard for not guilty by reason of mental disease or defect, or NGI, as you'll hear it. You've heard it referred to, and you'll hear it again, I'm sure. There's going to be a lot of discussion about potential diagnoses or diagnoses that were considered and not made. And Dr. Glassman certainly has the education and training to make those diagnoses and to consider them. And he's reached a conclusion on the issue of NGI. He does not believe Mr. Flatoff, in fact, was NGI at the time of the events on December 5th. But that conclusion does not have to be your conclusion. His conclusion needs to be supported. His conclusion needs to convince you that it is more convincing than evidence that shows that Brian was NGI during the events on December 5th. So as you listen to his testimony, I encourage you to take it in that light. Dr. Glassman has the benefit of experience, training, and education. One of the ways I believe that he's limited, though, is he did not know Brian Flatoff during the weeks, months, years leading up to December 5th. You will hear testimony from, again, Eva Lawson-Kransky. She took him to many of his doctor's appointments. In fact, you'll hear testimony that it was at her insistence that Brian finally started to seek mental health treatment. You will hear her describe what she viewed as his symptoms. Symptoms that were reported before he found himself in legal trouble. I know there is a tendency to think of NGI or insanity as the easy way out, as an excuse, as a, I didn't do it. That's not the truth. The law requires that if someone is going to be held accountable criminally for their actions, they have to have the ability to control those actions. And if not, the law holds they cannot be held accountable. So as you listen to the testimony, try to remove from your minds ideas of people avoiding responsibility and assess the evidence that's presented to you fairly. Is it convincing? Is it not? If it's convincing, apply it as the law demands. And again, I encourage you to hold me to the burden that the defense has. And as you hear the testimony, it's my belief that you will find that we've met it. Thank you.
Mr. Seaman. Thank you, Your Honor, Counsel. With all due respect to Attorney Szilagyi, I disagree with the statement that Dr. Glassman's testimony needs to be supported. It does not. I have no burden here anymore. The defendant has been found guilty of the counts charged, and now it's up to the defendant to satisfy you to a reasonable degree of certainty by the greater weight of the credible evidence that he should not be held responsible for those convictions you handed down last week. And he's not going to be able to meet his burden. Because when the defendant entered the special plea of insanity, the court appointed an independent doctor to provide an evaluation to reach a conclusion regarding the plea the defendant entered. And that doctor came back not supporting the special plea, the insanity plea by the defendant. In this phase of the trial, you're not going to be able to watch a video and hear the digital evidence of the defendant's guilt like we did last week. As close as we can bring you to that is the independent psychiatric evaluation. That's as close as you can get to it, to seeing for yourself what's going on inside his mind on December 5th, 2015. Scientifically medicated, that's as close as you can get, and the best evidence, independent evidence. He's the only witness who will be qualified to provide you any type of legal diagnosis. And his diagnosis was that on December 5th, 2015, the defendant was expressing no symptoms of depression or anxiety or PTSD, which he stated maybe, he might well have been diagnosed with in the past, but he exhibited no symptoms of that on December 5th. And part of his evaluation of the defendant is reviewing past evaluations and records of other doctors. And one of the evaluations that he reviewed was from the Dr. Neese from the Outagamie County felony case that he was on bond for. And that evaluation was done on November 15th, in November 2015. And that doctor's evaluation came back not supporting NGI. And he reviewed another evaluation that was done after the incident. That evaluation was done by Dr. Merrick in March of 2016. And not only did that doctor opine the defendant was not insane, should be responsible, but also that he was malingering, fudging the facts, trying to pretend to be insane to the doctor. So even though Dr. Glassman's opinion does not need to be supported, it is supported, not only by other evaluators, but by the simple facts of this case. And I'll ask that you find the defendant has not met their burden, and you should not escape responsibility because of this plea. Thank you.
All right, thank you, Mr. Seaman. Mr. Szilagyi, are you ready to call your first witness?
Your defense would call Dr. Nathan Glassman.
Dr. Glassman, if you take the stand here, and then raise your right hand.
Do you solemnly swear that the testimony you shall give in the matter now before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You have a seat.
Good morning, Doctor. Could you state your name and spell the last name for the record?
Yes, name is Nathan, N-A-T-H-A-N, Glassman, G-L-A-S-S-M-A-N.
And you were appointed to examine Mr. Flatoff by this court, correct?
Yes.
And could you give us a brief overview of your qualifications in the area of psychology?
Yeah, I'm a licensed psychologist in the state of Wisconsin. I've been licensed since 1991. I have board certification in clinical psychology and in neuropsychology, and I have extensive continuing education in forensic psychology.
Thank you. When did you examine Mr. Flatoff?
On January 18th.
And how long was did that examination take?
It took approximately 5 hours. There was a morning session and an afternoon session.
And do you have let me back up. Have you been appointed to, or hired to do similar evaluations in the past?
Yes.
How many times would you say you've had that experience?
More than 20 or 30. I had my first NGI eval in about 1992.
So over the course of, say, 25 years, it seems like maybe about 1 a year?
1 or 2, yes. It ebbs and flows.
Is there a standard practice for an NGI evaluation?
In the state of Wisconsin, because of the legal standard, the questions addressed in the way that I've been trained by other board certified practitioners to use the legal standard. So answer, yes, there is a standard of practice.
Sure. And I apologize, I don't think I asked that question well. Is there
All right, everybody, that is a live feed in the Brian Flatoff case. That's Dr. Nathan Glassman, who's going to talk about his psychiatric evaluation of the defendant in this case and whether or not he suffered from a mental defect and therefore would not be responsible for his actions. Again, I'm here with former prosecutor Carissa Kranz. You heard what the defense basically said in their opening, that he suffered, that, you know, there's potential diagnoses, there's things here that he might have suffered. We talked about alcohol a little bit earlier, but they're talking about a mental defect here. What do you think they're going to go with?
They may go with PTSD. They know that alcohol is not a legal defense because voluntary intoxication is not a defense. So the defense is going to try to stay away from that. They have to just prove by the preponderance of the evidence that he had a mental illness or defect that was severe enough at the time that the acts of the crimes were committed. So in this case, I think that that's what they're going to go with, and they're going to rely on the psychiatrist's records. But in the opening statement that you just heard there, you heard them say that this is the only time that you're going to hear about his mental state. This is the only evidence that you are to consider. But it's important to remember that the jury is the same jury that heard him give an opening statement. So they already heard from him directly about his mental state, of how he thought those events happened.
That's right. It gave them a good insight into the man himself. Well, let's listen back in.
And would you mind giving us an example of, well, would you mind telling us what you did in this instance to prepare for this evaluation or report?
I looked at the criminal complaint. I looked at some of his mental health records. I talked with one of his friends for collateral information. I looked at previous reports that had been authored on the defendant for criminal responsibility. I did an examination for the presence of a mental disorder and a cognitive disorder as well.
Was it your understanding that Brian felt justified in his behavior on December 5th?
Welcome back, everybody. That's a live feed in the Brian Flatoff case. That's Dr. Nathan Glassman, a psychologist. But we have to really dissect what he's saying right here. I'm here with former prosecutor Carissa Kranz. I believe he was called by the defense, but what he said so far is not so good for the defense. I don't hear that mental defect. I don't hear anything about Brian Flatoff really suffering from a mental defect. We heard him maybe being intoxicated, and maybe there was a lapse in memory there, but it's not the same thing. What did you make of this so far?
Right. Well, I believe he's a court-appointed psychiatrist, so he's there to give an opinion based on his assessments and based on witnesses that are interviewed and based on prior medical history that's being evaluated on whether or not there is a severe enough mental defect that could qualify as a legal defense. From what I'm hearing so far, it doesn't appear to be that. He's blaming alcohol, which, you know, legally voluntary intoxication is not a defense. The blackout, while he did say that dissociative amnesia is considered a mental disorder under psychology rules, that's not my thing, but it is considered a mental disorder. In this case, it doesn't appear that they are actually linking it to a mental disorder that would have been consequential to him committing these crimes. They did have a brain MRI, which, to recap, they found a lesion on his brain, which could contribute to blackouts. But they also said that that brain MRI was inconsequential as well. It's normal to black out when you are drinking. It's normal to black out if you have a brain lesion, and it's normal to black out when you're going through a traumatic event and your adrenaline is going. From what I'm hearing so far, none of this would qualify as a legal mental defect that was so severe that meant that at the time the crimes were committed, he didn't appreciate the difference between right and wrong and what he was doing. And also, another interesting thing that they brought up was at the time he was interviewed by the police, he was able to recall facts of what happened. So that shows that he didn't black out. There wasn't an amnesia of the event. There might be a convenient amnesia for his defense, but it doesn't sound like there's a real legal mental defect that would qualify an NGI, which means not guilty by reason of insanity, argument here.
Yeah, again, you're watching the Brian Flatoff case, a man who was found guilty by a jury last week on 14 charges, including felony murder and 2 counts of attempted murder in relation to an armed standoff hostage situation at a motorcycle repair shop that resulted in the death of one person, Michael Funk. And now this psychologist is on the stand talking about whether or not Mr. Flatoff suffered from a mental defect and shouldn't be held responsible for his crimes. From what we've just been talking about, doesn't sound like it. Let's listen back in.
I think it would depend, but delusional beliefs, my understanding is that in general they're about something that is not true, such as a person believing that other people are out to hurt him or another way harm him, or maybe a person believing that they're infected with germs when that is not true.
If I understood what you said correctly, is it accurate that as a clinician you look to perhaps the most likely cause first in assessing a diagnosis?
Yeah, I would say that's an accurate characterization. In medicine, there's an expression: if you hear hoofbeats in the street, you wouldn't automatically assume that it was a zebra.
Although it could be, reason says otherwise. Is that right?
It's.
And it's your opinion to a reasonable degree of medical and scientific certainty that on the date of December 5th, 2015, the defendant could conform his conduct to the requirements of the law?
Yes.
And it's your opinion that on that same date, to a reasonable degree of medical and scientific certainty, that the defendant could appreciate the wrongfulness of this conduct?
Yes.
And you see the Brian Flatoff in court here today, who you met with for 5 hours and performed his evaluation.
Well, there you have it, ladies and gentlemen. That is Dr. Nathan Glassman, a psychologist who was brought forth by the defense to hopefully show that their client suffered from a mental disease or defect and couldn't appreciate the wrongfulness of his conduct, or maybe even couldn't conform his behavior to the requirements of the law. But as you heard this witness just said, that wasn't the case. Again, I'm here with former prosecutor Carissa Kranz. Okay, this guy was brought in, really not helping the defense's case any which way.
No.
What's going to happen now?
It seems like they're listing every possible defense that could lead to a mental defect. They're listing out intoxication. They're listing out dissociative amnesia, antisocial personality disorder, multiple personality disorder, depression, anxiety, you name it, they're trying it, and this psychiatrist isn't buying it. He is saying after each one, during the wrap-up, that at the time, it is in his professional opinion, that at the time the crimes were committed, that he could appreciate the difference between right and wrong. And even though he may have a prior history documented of episodal moments of these diagnoses, that he has no evidence at the time the crimes were committed that they would have contributed to any mental defect at that time.
You got to explain this to me, because this witness was brought forward by the defense first. If this is their first witness, who's their second one going to be?
Well, it'll be interesting to see. We can keep watching, but it seems like this witness is basing his professional opinion not only on his evaluation, but on other reports that he was given to review and based on a prior medical history. So the jury, which is the same jury that came down with the guilty verdict, is going to have to lend insight based on weigh the evidence based on this professional's diagnosis, based on the reports that are being, read into evidence and the testimony. And then, they did hear directly from, let's not forget, they heard directly from Mr. Flatoff in opening statement since he represented himself. So they are going to have insight on what they think his mental state was at the time based on the way he presented his case. Even though opening statements are not evidence, it's going to be very hard for a jury to pretend that they never heard that. They heard it. So from what we hear right now, this not guilty by reason of insanity, in my professional legal opinion, I don't think it's a credible defense. We can continue to hear what else comes down, but just from this expert, and this is a battle of the experts, it doesn't sound like a credible defense. But you never know what a jury's going to do. I've been surprised in the past, and you know, juries. I've been surprised.
Well, we should note that Brian Flatoff, if the jury doesn't buy this, that he was suffering from a mental disease or defect, the maximum sentence he could receive is upwards of 300 years in prison as a result of what he was convicted of last week. The 14 counts, including felony murder and 2 counts of attempted murder, in relation to an armed standoff that he had with police where he took hostages, fired his weapon at police, and one man, Michael Funk, was killed as a result. He was shot by police who mistakenly thought that he was the armed suspect in this case, but it was a mistake. Michael Funk was just an innocent hostage, and he was killed, and it's a really sad case. And now the determination is, after Brian Flatoff was already found guilty, what will his behavior be excused? And I have to tell you, we have covered a lot of cases here on the network where insanity goes toward the jury and they really don't buy it. So we're going to have to listen in. And before we come back, Carissa, stand by. I do want to let our viewers know they were carefully keeping an eye out in Ohio for the James Worley case. As soon as we have a live feed in that case, we're going to make sure to go to it. This is that case, that 58-year-old man, who was on trial for the abduction and murder of a 20-year-old University of Toledo student, Sierra Joggin. And he is accused of kidnapping this young girl, taking her back, asphyxiating her, and leaving her body, her bound and gagged body, in a shallow grave. A really disturbing case. We are carefully monitoring it. As soon as we have a live feed, we will make sure to go into that courtroom. Now, Carissa, I know we don't have much time left, so final thoughts here on the Flatoff case. What do you expect the defense to continue to do with experts, and does the prosecution really even need to put on their own witnesses after what we're watching today?
Well, it's going to be interesting to see what happens. It doesn't end here, that's for sure. The defense is going to continue. The defense is going to continue putting on their witnesses, and they're going to continue trying to prove that he's not guilty by reason of insanity. It's important to remember that it is the defense burden in this case. It is not the prosecution's burden to prove insanity now that he's already been found guilty, and that the standard is not beyond any and all reasonable doubt, is clear and convincing evidence and the preponderance of the evidence. So it is a much lower standard. So it really does depend on what the experts are going to say, but based on the testimony we've heard so far, the experts seem to be saying that at the time the crimes were committed, that he could appreciate the difference between right and wrong, and that there is no severe mental defect that would be a legal defense. But even there, you can expect that this isn't going to end, because if he doesn't win on the insanity defense, then he's going to be spending his time in prison, and you can bet that we will see appeals come down for ineffective assistance of counsel, for all sorts of issues, since he went through 10 public defenders and trying to prove his own case. So, you know, this definitely isn't the end. This is just part of the theatrics of a jury trial.
And we'll have to see what happens. As you saw, Dr. Nathan Glassman, the psychologist in this case, left the stand. We're waiting for the next witness. Carissa, thank you so much for your time today and helping us out. We really appreciate it.
Thank you.
Well, actually, while I have you, one last question. Yep. We know the James Worley case is coming up in Ohio. We know Tex MacGyver opening statements tomorrow. We see this next witness coming on. Just real quick, I know this next witness is coming on. Real final thoughts on the James Worley case out of Ohio.
Well, I'm glad they finally got a jury. I mean, that is a big media case, and it's really hard to pick a jury when you have a big media case, because you need to have an unbiased pool of jurors who can determine the defendant's fate without any prejudice, and they must be able to follow the law. So that case is complicated. It has lots of tentacles, especially because it is a death penalty case, and a lot of jurors are afraid of the death penalty.
Carissa, thank you so much. All right, everybody, we have our next witness now in the Brian Flatoff case. Let's listen in.